Hey everyone, and welcome. Today, we're going to put on our detective hats and solve a really fascinating legal puzzle. We're going to dive into how judges figure things out when the rules themselves aren't as clear as you'd think. So let's set the scene. Imagine you've been in a dispute. You decided to use arbitration to keep things quick and simple. And guess what? You won. That's awesome. You now have what's called an arbitration award, which is just the official decision saying you're owed money. Now comes the easy part, just collecting what you're owed. Or is it? What happens when the finish line suddenly seems impossible to reach? Well, that exact problem is at the very heart of this case. Evergreen Solutions versus Depositario. It starts with what looks like a super simple question about getting paid. But the answer? Oh, the answer is buried under layers and layers of legal rules. Okay, so here are the basics. A company, Evergreen Solutions, wins an arbitration award. To actually get the money, they head over to the small claims court. You know, the place that's specifically designed to handle financial disputes in a straightforward, no-fuss kind of way. But then, bam, they hit a wall. A huge question pops up. Does the small claims court even have the legal power to enforce an arbitration award? And that, right there, is the mystery we need to solve. To crack this case, our first step is to figure out if any court is allowed to get involved in the first place. We've got to find a way to open that courthouse door. And to do that, we need to start looking for clues in the law. And right away, we find our first big plot twist. See, the Arbitration Act has this general rule that basically says, hey, courts, you need to stay out of arbitrations. The whole point is for it to be a separate process. But, and this is a huge but, there's a key exception. Section 6.24 clearly says that courts can step in for one specific reason, to enforce an award. So yes, there is a way in. Okay, great, the door is officially open. And Section 50 of the Act even tells us how to walk through it. It says you can make an application to the court for enforcement. Everything seems to be lining up perfectly, or so we think. But not so fast. Just because we can go to a court, that doesn't necessarily mean we can go to any court. And this is where our simple case suddenly gets really complicated. It's like we've solved one puzzle only to find a much bigger, trickier one waiting right behind it. And here it is. This is the clue that just stops everything in its tracks. The Arbitration Act itself actually defines the word court. And according to Section 1, court means either the family court or the superior court of justice. Notice what's missing? Yeah. The small claims court is nowhere on that list. So, what does that mean? If the small claims court isn't explicitly mentioned, is that it? Game over? It sure looks like a dead end for Evergreen Solutions if we just stop reading right here. But here's the thing about laws, and really about any good detective story. They don't exist on their own little islands. They're all part of this giant, interconnected web. To find the real answer, we have to keep digging and follow the trail of clues into other laws. And when we do that, check this out. We find this little gem in a completely different law, the Courts of Justice Act. Section 22 of that act says that the small claims court is actually a branch of the Superior Court of Justice. Whoa, wait a minute. Suddenly that restrictive definition doesn't seem so restrictive anymore. They're connected. So why is this such a huge deal? Well, let's talk numbers. The small claims court is specifically set up to handle cases up to a certain dollar amount. As of 2023, that's $35,000. It is literally the court built for exactly these kinds of financial issues. It's the most logical place in the world to go. Now, this next clue is maybe the most powerful one of all. It's like a secret decoder ring for judges. The Legislation Act actually tells judges how they're supposed to read all the other laws. It says you can't just get bogged down in the literal words. You have to give them a fair, large, and liberal interpretation to make sure the law actually achieves what it's trying to do. This completely shifts our focus from the what to the why. So we have all our clues. We've got the specific rules, we know how the courts are connected, and now we have this amazing guiding principle on how to interpret everything. It's finally time to put all the pieces of the puzzle together and figure out the final verdict by focusing on the purpose behind all these laws. And this isn't just some random idea. It actually has a name. It's called the Modern Approach to Statutory Interpretation, and it was famously laid out in a case called Rizzo versus Rizzo Shoes. It's a pretty straightforward method.
You read the words, of course, but you have to read them in their full context and interpret them in a way that works in harmony with the law's main goal.
So let's ask that big question. Why do we even have things like arbitration and the small claims court? What is their purpose? Well, it all boils down to a few really simple, important ideas: to be fast, to be inexpensive, and to make sure everyday people have access to justice. The whole system is designed for one thing: efficiency.
And that leads us to the final, crystal clear conclusion, the aha moment. If you force someone who won a small arbitration award to go through the hassle and expense of the big, complicated superior court, you completely defeat the entire purpose of having these speedy, low-cost systems in the first place. It just makes no sense. So the only interpretation that works is that the small claims court must have the power to help. In the end, the spirit of the law won.
This whole legal puzzle really shows that sometimes the most important part of a rule isn't just what it says, but the reason it was created. So I'll leave you with this to think about. How does understanding the why behind a rule, whether it's at work, at home, or anywhere else, change the way you see the rule itself? Thanks for digging into that with me today.